So, good morning. Do you hear me? I hope. Do you hear me? Yes. And thank you very much for being here. It's thank you for the invitation from the notaries of Europe, to be among you, to co-organize along with you the Council of the Notaries of the EU, to speak about the protection of vulnerable adults, a topic of paramount importance, and you can understand it's a topic that it is very close to my heart. In our ever-evolving world, the number of vulnerable individuals, the elderly, disabled persons, or otherwise impaired people, is on the rise. This is a reality that we cannot ignore, and we need to face the issue in the right of each core, in the center of each core. 95.3 million people in the EU are at risk of poverty or social exclusion. About 87 million people are reported having an impairment, while 84 million people in the EU are estimated to live with mental health disorders. So it's very crucial, and the numbers are quite big. So we need to act. On top of that, Europe has a significant aging population and is on the brink of a major demographic shift, as the new projections suggested a significant population decline by the end of the century. These increasingly vulnerable groups of adults require cross-border protection and care, which presents a unique set of challenges. Oftentimes, different rules and procedures create barriers for vulnerable adults and their families, something that we don't need to forget. To have their rights and protective measures recognized in cross-border situations. The European Commission's proposal for regulation aimed at strengthening the safeguards for this individual, as well as the Council decision to ensure that all member states will soon become party to the Hague Convention of 13 January 2000 on the protection of adults, offer a significant stride towards resolving these challenges. The proposal of the regulation seeks to facilitate not only on the determination of the competent courts in the member states, but also the determination of the applicable law. Moreover, it aims to streamline the recognition and enforcement of protection measures taken in other member states. This is a crucial step forward in the pursuit of a more digital, enhanced, interconnected, and efficient system, ultimately leading to a better quality of life for our vulnerable adults. By establishing national registers and fostering their interconnections, this initiative will not only break down procedural barriers, but also create a more robust framework for cross-border protection. The advantages are numerous. It ensures a swifter response in cases of vulnerability, minimizes legal complexities, and fortifies the protection mechanisms for those who needed it most. In a world where borders are becoming less and less significant, where people move freely and reside in different member states, it is our obligation to ensure that the protection of vulnerable groups, adults, knows no boundaries. The proposals from the European Commission represents a momentum step towards a more inclusive, caring, and united Europe. As we move forward, we must remember that the strength of any society lies in how it cares for its most socially vulnerable members. This is an opportunity for the European Union to provide hope and security to those who need it the most. It is important to build a future where the protection of vulnerable adults transcends borders and stands as a testament to our common values. But let's discuss exactly how the proposal will help achieve that and what we need to change. Really thank you for this creation of the event, and I'm very happy that you see so many people to have these concerns, and because we can understand that the problem, what they face, is something that concerns all. Thank you very much again.
Thank you very much, Mr. KYMPOUROPOULOS.
Ladies and gentlemen.
And now I wanted to say there will be a video message.
Thank you for your invitation and for organizing this conference on the cross-border protection of adults in the European Union. This event is particularly timely, as today is European Day of Justice, and justice should be available to all. So, let me thank the organizers of this conference for giving a voice to those who are not always heard. Citizens who, because of an accident, sickness, or disability, need specific support and protection. With an aging and increasingly mobile population, the number of cross-border cases regarding the protection of adults will certainly increase. The Commission's recent legislative proposals on the cross-border protection of adults aim to meet the needs of these citizens. As you probably know, this is not an area in which the European Union can adopt substantive. This is the responsibility of the Member States. But what the EU can do is to try to remove legal obstacles in cross-border cases. In this regard, we propose a set of harmonized and efficient European rules. In cross-border cases in the European Union, a protection measure taken in one member state should be automatically recognized in the others. And the proposed European Certificate of Representation aims to help representatives of adults to evidence their authority in a simple way in any EU country. Above all, we want to safeguard the right of citizens to make their own choices. Adults who have sought support from a family member or another representative must have their wishes respected across the Union. European notaries are key actors in ensuring the right to autonomy. So, let me thank the Council of Notariats in the European Union for its engagement regarding this initiative. I hope that these proposals will soon be adopted by the European Parliament and by the Council. I thank you for your attention and I wish you fruitful discussions.
So now it's my turn, I guess. Dear Mr. KYMPOUROPOULOS, dear honorary guests, on my left-hand side, right-hand side, dear colleagues and friends, good morning, everyone. Welcome to our conference on the protection of adults. On behalf of the CNUE, I would like to thank all of you for joining us this morning on the European Day of Justice, be it here in person or in the European Parliament or online from all over Europe. I would especially like to extend my gratitude to you, Mr. KYMPOUROPOULOS, for hosting us in the European Parliament. It's truly an honor for me and for the notaries of Europe that we can hold this conference together here with you on this very important, you called it paramount, topic right here at the very heart of Europe. The next 2 hours will be exclusively dedicated to the protection of adults in Europe, especially in cross-border situations. That this topic is of great interest shows today's participation. We have about 60 participants here in person, and we have more than 100 registered people that have joined us online. So welcome to you as well. The European Commissioner for Justice, Mr. Didier REYNDERS, as well as our host, MEP Stelios KYMPOUROPOULOS, have already addressed us. In my view, their speeches have been the perfect start to our conference. They highlighted the paramount importance of the issue at hand for each of us. Thank you very much for that. And with view to today's agenda, which you have at your hand, I hope at least, we can look forward to further interesting interventions and discussions. For example, we are going to hear from my highly valued colleague, fellow CNUE board member and dear friend Eftychia KARASTATHI. Eftychia became a notary in Greece in 2004, and since then she has actively been involved in furthering and improving the notarial profession, both on a national scale and on an European and international level. She is an expert and passionate advocate for the protection of adults. I'm also very happy to hear her insights on today's topic. We are also going to have a panel discussion moderated by my dear colleague and president of the Human Rights Working Group of our International Union of Notaries, Almudena Castro Girona. Welcome, Almudena. Almudena too has been a great advocate for the effective protection of adults for many years, and we are really glad to have you here as our moderator today. The panel discussion will be joined by Marie Vautravers, Secretary of the European Judicial Network in Civil and Commercial Matters. Welcome. Ruth Alvarez Vinagre, Counselor of the Ministry of Justice at the Permanent Representation of Spain to the European institutions here in Brussels. And last but not least, Marine Uldry, the Human Rights Policy Coordinator for the European Disability Forum. Welcome to all of you. I will leave the honor to Almudena to properly then introduce our panelists. However, on behalf of the CNUE already, I would like to thank each of them for agreeing to be part of today's panel discussions. Before I give the floor to Eftychia, I would like to say just a few words. We have already heard something about the protection of adults and its importance, especially for the notaries of Europe. In May, the European Commission adopted its legislative proposal. It includes 2 instruments. One, a regulation that will govern especially cross-border cases of the protection of adults among EU countries, and a Council decision that will oblige EU countries to become or remain parties to the Hague Convention on the Protection of Adults. The intention behind this proposal is crystal clear. People requiring protection rely on others. to help them, one, exercise their rights, and two, protect their interests. For their representatives, regardless of whether their status is based on a judicial protective measure or private power of representation, power of attorney, proving their powers can be a challenge, especially in cross-border situations. This is even more so in a cross-border context where people rely on legal instruments which have been drafted in one member state or adopted in one member state and then need to be recognized in another member state. Therefore, for this very reason, the Commission's legislative package comes just at the right time. Why? We have already learned this. European population is growing older. It's almost banal to say, we all know this. And as a result, there is an increasing number of people in need for support and assistance. And at the same time, people become more and more mobile. As president of the CNUE, I can say that the CNUE highly welcomes the European Commission initiative as well as the goals and values expressed in it. The fact that the European legislator is aware of the increasing need for a harmonized legal framework and reacts accordingly is a very important step towards a more inclusive European society. And the legislative package will achieve this goal. We are pretty confident about that because, one, the Council decision will ensure that all EU members will soon also be members of the Hague Convention. Once this is the case, the rules and principles set out therein will serve as at least a minimum standard for also non-EU countries which have ratified that very Hague Convention. And the regulation, on the other hand, will provide additional streamlined rules and practical tools that are intended to make the legal framework even more effective and efficient in practice. And last but not least, the European Certificate of Representation on the interconnection and the interconnection of protection of registers are also two examples for how the protection of adults will become easier and more efficient in the future. At the same time, the protection of adults is not only a relevant issue in light of the current legislative package. Its importance, especially for our notarial profession, goes far beyond. I have said before that one of the most essential aspects of our role as notaries is to be guardian for the weak in society. And I stand by that statement personally. And this is why I made it one of the priorities of my this year's CNUE presidency. This is also why the CNUE has been very active in this field for many years. We continuously offer legal training for notaries in this very field. We also seek to raise awareness among the public. For instance, we have set up the website, and you can consult it, Vulnerable in Europe. It's supported by the European Commission, and it offers a very comprehensive overview of judicial and extrajudicial and preventive protection measures for minors and adults in 22 EU countries. And we also work towards intensifying the dialogue with other associations which are active in this field. Our aim is here to better understand the practical difficulties encountered in cross-border situations. And this is also one of the aims, and here I come back to today's conference. That being said, I would like to wish everyone a wonderful conference. I myself am very much looking forward to listen to what will certainly be most interesting and fruitful discussions here at our panel. Thank you very much, and Eftychia, now the floor is yours. Thank you.
Thank you, President. Dear MEP KYMPOUROPOULOS, dear President STELMAZCZYK, dear representatives of the European institution, dear colleagues, good morning. In the name of the European Greek Notariats, I would like to thank MEP Kympouropoulos for organizing this conference at the European Parliament on the occasion of the European Day of Justice. This event is of huge importance to us. The objective pursued by the European Day of Justice is to bring justice closer to all European citizens by informing them on their rights and on the available tools in place for facilitating access to cross-border justice. This is the reason why I am convinced that the topic of today's conference, namely the cross-border protection of adults, is particularly well chosen. Against the backdrop of Europe's aging population and the ever-increasing mobility of our fellow citizens within the European Union, the European Commission's legislative package on the cross-border protection of adults is a first step towards putting in place effective tools to meet the challenges we are facing. In particular, the proposal for a regulation is a significant step forward in ensuring the respect of the rights of autonomy enshrined in the United Nations Convention on the Rights of Persons with Disabilities. I am convinced that this proposal will considerably facilitate the circulation of powers of representation granted in advance by an adult for a time when the adult will not be in a position to fully protect his or her interests. It focuses on creating a safety net for adults. Access to justice for people with disabilities is a major social issue and therefore a challenge for the European Union. The construction of the European Union is part of the defense of the rule of law in which we live. Europe is not just limited to the internal market. The rule of law also prevails. It is the duty of the European Union, but also of practitioners, including notaries, to ensure that citizens' rights can be properly executed. We need the appropriate legal instruments to address these situations. The European Union certainly hasn't been inactive on this issue. In 2021, the European Commission presented its strategy for the rights of persons with disabilities for the period of 2021-2030. The strategy sets out European objectives and actions priorities in several areas, such as accessibility, citizens' rights, quality of life, equal access and non-discrimination, and the promotion of the rights of persons with disabilities. The implementation of this strategy is underway, and the United Nations Convention on the Rights of Persons with Disability has not been forgotten. A disability platform has been created, which brings together national authorities responsible for the implementation of the Convention, disability organizations, as well as the Commission. The purpose of this platform is to support the strategy implementation and to strengthen cooperation and exchanges of the implementation of the Convention. However, we still could and should do more. Let's remember the main objective of the United Nations Convention, which entered into force in May 2008. It is to ensure the full and equal enjoyment of all human rights by persons with disabilities. In this context, let me insist on the need that Article 12 of the Convention on the equal recognition of the legal personality and Article 13 on the access to justice should be treated to their just importance. Indeed, these articles are of paramount importance from the point of view of the exercise of rights with the necessary support. They are therefore of primary interest to the notary, who exercises this institutional support so that persons with disabilities receive all the information and recommendation necessary for the exercise of the rights at a level playing field. That is why helping to strengthen the support provided by notaries is a priority for our institution. This is a prime concern at European level through the Council of the Notariats of the European Union, as mentioned by President STELMASZCZYK in his speech. This is also the case at a global level through the International Union of Notaries. Today, we are lucky to have amongst us Speaker Mrs. Almudena Castro Girona, President of the Human Rights Commissions of the International Union of Notaries. I am confident that she will provide us with a valuable insight into significant work being carried out by the Union in this area. Let me insist on the fact that the rights of people with disabilities are a matter of concern for all of us, and the notarial profession does not fail to meet its responsibilities. Indeed, the institutional support provided by notaries enables persons with disabilities to receive all the information they need, as well as specific recommendations to allow them to exercise their rights on an equal footing with the assurance of full legal certainty. Notaries provide this support by means of a judgment of capacity, or more specifically, by means of a judgment as to the discernment or understanding of the specific act being performed. For this very reason, we must also ensure that our colleagues receive adequate training so that they can fulfill their role properly. This is particularly the case with regard to the capacity judgment. It is necessary that such judgment is done effectively in order to ensure that it does not result in a de facto restriction of legal capacity. Every situation and every person is unique. People with disabilities are not a homogeneous population, and for this reason, they must be able to benefit from a differential treatment adapted to their specific needs. The standardization of support procedures is not and never will be a viable solution. In this respect, it is essential that we strengthen our links with organizations respecting people with disabilities and representing them, such as the European Disability Forum, present here today at the conference, which I would like to welcome. This would help us to better identify the specific needs of persons with disabilities. We also need to pursue our efforts to communicate about the issues at stake in applying the Convention, both to the general public and to our governments, to ensure that our national systems are brought and kept in line with the main principles of the Convention, a key concern of Greek notaries as Greece ratified the Hague Convention in 2022. Lastly, at the notarial level, we must ensure that we actively promote legislative reforms recognizing the exercise of legal capacity within the context of the Convention. Dear colleagues, the UN Convention has introduced a paradigm shift. Our response must be commensurated with what is at stake. Please rest assured that the notarial profession will always be a trusted and supportive interlocutor to help finding solutions to the considerable challenges that lie ahead. Thank you for your attention.
This is just to let you know that Mr. Kympouropoulos has to leave now, and thereafter I will give the floor to Almudena for the panel discussions. Thank you very much.
Sorry, we are organizing the table. Good morning to everyone. Thanks for the organization, and thanks for the president of the CNUE and the parliamentary that has left us today. Mr. Stelios KYMPOUROPOULOS, sorry for my pronunciation, I don't speak Greek. So let me introduce you, as the president said, the panelists that are with me, the speakers with me. On my right hand, the first one is Marie Vatrouvet, more or less, yes. French judge, currently working as national expert of the Civil Justice Service at the DG Justice and Consumers European Commission. Okay. She is also the secretary of the European Judicial Network in Civil and Commercial, and one of the persons responsible for the Commission's proposals on protection of adults. Okay. Thank you very much for coming. On my left hand is Ruth Alvarez Vinagre. Is a state attorney in Spain, part of the Spanish legal service in the Ministry of Justice, Directora General for International Legal Cooperation and Human Rights.
I'm part of this directorate.
Okay, thank you. She's a justice conciliar at the Spanish Permanent Representation to the European Union. And as a part of Justice team during the Spanish presidency of the Council. She chairs the Working Party Group on Civil Law Matters, dealing with the negotiations on the Commission proposal for a regulation on jurisdiction, applicable law, recognition and enforcement of measures and cooperation in matters relating to the protection of adults. With expertise at the national and European levels, as she was also working in the European Commission, Ruth provides valuable legal analysis expertise from both perspectives. Thank you very much, Ruth. And on my right hand, I have Marine Uldry. Yeah. Marine works on human rights issues affecting the rights of persons with disabilities and contributes to the EDF, advocacy to the European Union, Council of Europe and United Nations. She supports the work of the EDF Women's and Human Rights Committees, develops EDF's Women's Voice newsletters and coordinates the advocacy against the draft additional protocol to the Oviedo Convention. That's right. She is also in charge of supporting the engagements of EDF members with the committee, that's right, of the rights of persons with disability, and the Committee on Elimination of Discrimination Against Women and the Councils of Europe's group of experts on action against violence against women and domestic violence. So, and myself, I am Almudena, and I'm not going to introduce myself. Okay, I think we have to go to matter. It's important, and at the beginning, I think I'll throw some questions to you. You have more or less 5 minutes each of you to answer them, and I would like to read this live and participate. So, let me, Marie. Could you please elaborate a little bit on the context that led to the European Commission adopting this legislative package, on the protection of adults? What are the objectives and the goals that the Commission and the European Parliament wants to achieve?
Thank you very much. Good morning to you all. It's a great honor to be here today in the Parliament on the European Day of Justice, and I'm very grateful for CNUE and Mr. KYMPOUROPOULOS for organizing this event. It's really a pleasure to be able to discuss our proposal with a panel of knowledgeable experts, and I'm really looking forward to the discussion. So to say a few words on the objectives of our proposal. So as it was already recalled, it's a proposal for a regulation that will apply in the EU and a proposal that all member states ratify the Hague Convention. And those rules would apply with the non-EU member states that will be party to that instrument. So why did we prepare and propose this legislative package? Well, basically it was to solve the problems that were reported to us from people, practitioners in cross-border situations, in international situations. And we had three main types of problems that were reported to us. The first one was legal certainty. The second was the lack of recognition of measures and powers of representation. And the third problem was lengthy and costly proceedings. So to go back to the first problem, the problem of legal certainty. At the moment, you will have understood that there is no EU legislation on those cross-border cases, meaning that it's the national rules that apply, and we have a patchwork of national rules at the moment, which makes it impossible to predict in a specific case in advance which rules will apply, and it concerns all of us. It's really a problem for the general public. Let me take a concrete example of an EU official who would be a Luxembourg national and who would live in Brussels, who would have his, let's say it's a man, habitual residence in Brussels. If this person, for some reason, because of an accident, because of a stroke, a sickness, needs support, at the moment, there would be two completely different rules applying to his case, making it impossible to know exactly what will happen. Because this person is a Luxembourg national in Luxembourg law, the criteria to determine which court will be responsible is nationality. So in this case, the Luxembourg court would decide we have jurisdiction over this case because this person has the Luxembourg nationality. Same for which rules would apply to that case, which national legislation. For Luxembourg courts, they would decide that because this person is a Luxembourg citizen, they need to apply the Luxembourg laws on protection. But for Belgian courts, the criteria are not the same. So the Belgian court would consider that because this person has his habitual residence in Brussels, they will have jurisdiction over the case, and they will apply Belgian laws on protection to this case. So for the exact same case, two different courts would have jurisdiction, and two different sets of national laws would apply. So this is really just a very concrete example how things are going on at the moment. This is the first problem we want to solve. And the second problem is the lack of recognition of protection measures. We've already addressed this in the introduction speeches, and the lack of respect of the wishes expressed in advance by all of us, and in particular by those who need support. At the moment, and this is something that has been widely reported by practitioners, but also by all the respondents to our public consultation. There are so many difficulties for people to just close a bank account abroad if they are placed under a protection measure. And it's really problematic that if you have appointed in advance a representative, or if a court has appointed someone, this person is not able at the moment to manage your assets when they are abroad. It's extremely difficult, and in particular from non-judicial actors like banks, for instance, they create a lot of problems. They don't want to be liable if something happens to the assets of the person. And the same goes for wishes expressed in advance for powers of representation. And the third problem we had was the lengthy and costly proceedings. All those problems are, of course, intertwined. They are interconnected because you don't have legal certainty, there's no recognition, and then you have to face judicial proceedings that can be extremely long and extremely costly, and this is very unfair. That just because you're in an international situation, you have to face those extra problems. And to finish with, again, a concrete example that was reported when we prepared this initiative, we had the concrete case of a Greek national who was living in Germany with his German life and for medical reasons was placed in a long-term coma. And his wife so he was placed under protection measure by the German court, and his wife was appointed as his representative. And she tried to manage his assets in Greece, because this person living in Germany has assets in Greece. It took her 12 years to obtain the recognition of the German decision in Greece. 12 years of judicial proceedings. So you can imagine how complicated this is for those persons to face those proceedings. So to reply to your questions, we wanted to try and solve those problems.
Very clear, Marie, very clear. The example legal certainty is essential for us, for everyone, I think. And the example you have put on the floor, I think loads of us, the notaries, we see it in our office every day because people are traveling, they have assets everywhere, so it's very important for us. Ruth, I'll go to you. Can you please explain us how the member states they have reacted to the draft legislation presented by the Commission? What is the current direction of work within the Council? And can we envisage a common approach before the end of the current legislation period or not? What do you think? Your impression?
Thank you very much, Almudena. First of all, thank you very much for the Council of the Notariats of the European Union for organizing this conference. Thank you very much for Mr. KYMPOUROPOULOS. I hope it is well pronounced. So that's it, KYMPOUROPOULOS. And thank you to the European Parliament for organizing and hosting this conference here in the European Parliament. Thank you to Almudena for moderating this debate, and thank you to my colleagues for being here. And I think it's very good to share views about this important file. I think it's very important for all of us as citizens, first of all. Now, regarding your question, it's a good and tricky question. No, first of all, I think. Yeah, no, but I will. Let me first make an introduction. I think there is no doubt that the number of adults who are not in a position to protect their interests because of an impairment or insufficiency of faculties is constantly growing. It is also a fact that there is more and more cross-border movements, not only for tourist reasons, but also for temporary residents, for asset and second house purchases in other member states, and all the activities, all the services that are around this, such as health treatments, bank accounts. We are moving and moving every day more. So cross-border movements and cross-border situations are in our daily life, and we need to take it into account. For example, in Spain, data collected by the College of Registers in 2022 reflects that during 2022, around 600,000 immovable properties were registered in Spain, and of them, 88,000, which represent around 14%, were purchases by non-Spanish citizens, mostly or mainly European citizens. That shows the huge impact that this kind of regulation can have in our countries and in member states. The historical trend is upward and has been rising for several years. We have other European instruments that have demonstrated that the good results of having harmonized rules on jurisdiction, applicable law, recognition and enforcement of measures. And it's true that cooperation between member states and the mutual trust is essential and keep us strong in the protection of fundamental rights. Saying that, I think that all member states, I could say, I cannot talk on behalf of the 27 member states, but I could say that all of us share the values and the goals of this proposal, as it was also reflected in the consultations conducted by the European Commission at the beginning of this proposal. This doesn't mean that we will need to discuss properly this proposal within the Council. The European Commission adopted this proposal by the end of May, and we had the first presentation in the Council under the Swedish presidency in June. Now we are working hard, and we will do our best to progress on this file, but I'm afraid we won't be able to reach a general approach. But it's not because we don't want this file, it's not because it is not a priority for us, for the Council, for the co-legislators. It's just that it's a long proposal, 70 articles, and it's a new proposal. We have other EU instruments in other fields, but not in this field. So it needs to be analyzed article by article. It's the normal procedure in the negotiations in the Council and in the Parliament. You need to have a long debate, article by article, analyze the implications of each article in our national legal systems, because we need to take into account that we are doing and we are adopting European Union legislation, but this legislation, this regulation must be applied at national level. And each member states have their own particularities in their national legal system, and it's very important to address all the concerns so that it is possible at the end to apply, to implement this regulation at national level. So, yeah, we are doing our best, but we are at a very early stage. And we only have discussed the first articles, but we will continue working on this file, and I'm sure that our colleagues from Belgium, I see them here in the meeting room, I'm sure they will work hard as well on this proposal because it's very important for us. And the Parliament, I suppose they will do the same. We are in an ordinary legislative procedure and we will need to reach an agreement together to get the final result and protect adequately the adults. So thank you.
Thank you very much, Ruth. Well, we share the values, okay, and we share the goals. I think that's an important message. And we have this discussion on the floor. I think we cannot wait 12 years in order to take any protection or support measures. So it's a good news that we are discussing this, and I know you are working very hard, and dialogue and work and analyze and discussion is needed. So let me go to Marine. You work in the European Disability Forum, and the European Disability Forum is leading European organization on defense of persons with disability in the EU. And what is your opinion on the European Commission legislative package? And does the Commission proposal meet the expectation of associations like EDF? And I know, and I have to take into account that you are very keen on the Convention of Rights of Persons with Disability, and you are going to talk about that.
Exactly. So good morning, everyone, and thank you very much for the invitation. We're really happy to be here with you today. I also have to share the apologies of our Deputy Director who was supposed to speak this morning, but I'm very happy to replace him as I'm following this file very closely as well. So as was mentioned, the European Disability Forum, we are an organization defending the rights of persons with disabilities, but we're also an organization of persons with disability, meaning that all our decisions are taken by persons with disabilities, and we have members both in national countries, so National Disability Council, and also European organizations representing different disability groups, including people with intellectual disabilities and people with psychosocial disabilities who are the most at risk of seeing their legal capacity restricted or deprived, and who also might need support in exercising their rights. So EDF, we are already involved since at least 2018 around discussion of protection of adults. We're attending already conferences organized by the European Commission on the Hague Convention, and we had at that time already shared a bit of concern about the fact that the Hague Convention, because it was adopted in 2000, does not necessarily take into account all the development that have been made since then in relation to the rights of persons with disabilities. What we see is that this convention focuses very much on restricting the legal capacity of persons, so guardianship, and didn't really look at supported decision-making measure, which is something that since then has been required by the UN Convention, and I think there was already a few references to its Article 12. And so that's something that we raised in the past with the European Commission. We are really happy that we had this exchange with the Commission, and we saw that reflected in some part of the proposal, which is positive. But overall, the most important content of the proposal for us did not meet our expectation and the expectation of our members. Of course, we do support very much finding solution to conflict of law. I think the example of the Luxembourgish person is really striking, and the other example as well. What do we do in those cases? And that needs to be solved absolutely. We also support reducing costs for people, which is really important. But for us, what is problematic is this automatic recognition of measures that actually do not really support persons, but in some cases might deprive them of their rights instead of supporting them. So I stress the positive part that are actually mentioned in the recital of the proposal. So looking at Article 12, at access to justice, at independent living, but that's not really then reflected in the main provision. And what we see is actually almost like a copy-paste of the Hague Convention. And the fact that it's really a missed opportunity that supported decision-making, for example, do not seem to be covered by the proposal, despite the fact that we see that those measures are now existing in in more and more EU member states, actually. And that might also pose the question for notaries and the person who benefit for support decision-making, what will happen then if they are in a cross-border situation? Will this support be recognized automatically, or will it be only when it concerns guardianship and deprivation of legal capacity? So yes, we do advocate for more recognition and supported decision-making, and we also do advocate for deinstitutionalization. And one big issue also that we saw with the proposal is this provision placement. So this sort of obligation then to recognize a measure of placement taken by one member state and to apply it in another member state. And that's something that is also against the right of person with disability, against the UN Convention, and that is raised not only by EDF, but also by both the UN Special Rapporteur on the Right of Person with Disability and the UN Independent Expert on Older Person. So what we will do in that context is that we're preparing a concrete proposal because, as I said, we do not want to stop all the benefits from the proposal to not apply and just stop everything, but we want to be constructive in that regard and see how to best improve the content of the regulation so it can really benefit as well to persons with disability. So we can ensure that instead of talking about this best interest, actually protecting the weaker person in a society, actually making sure that their rights are respected and not just what we interpret the best interest to be. So we'll both be demanding this to the European Parliament and the Council, and actually our proposed amendment will be available later this week on our website, so quite concrete proposal that we'll also share with the Commission and you here. Thank you.
Thank you, Marine. I love you have come instead of the director because I am moderating an all woman on the table. So I think we have to put an eye on that. The Hague Convention is 2000 and the Convention of Rights of Persons with Disabilities 2006. Hague Convention is international law and the other one is substantive law. Yeah? So we have to manage how to adapt everything. And I think it's important that support decision-making document that has been done, for example, in Spain, because we can do it, and the legislation is adapted, can have effect in another member state. Okay. So now we are going to make some questions. I will address the question to one of you, but of course all of you can answer. The three of you can answer. So, Marie, why did the Commission decide to not depart from the Hague Convention? It's a direct question.
Very, very clear. We actually did depart from the Hague Convention a lot, but it's true that we have two chapters that are making a reference to this convention, and by making this reference, we make the rules of the convention applicable to the EU directly. So what are those two chapters? The first one is on international jurisdiction. It's about deciding which court has jurisdiction over a cross-border case. This is kind of a novelty from this regulation to make a reference to another text and to import rules on jurisdiction. And the second chapter is on applicable law. And again, we make the rules of the Hague Convention determining which law will apply to a cross-border case. We make those rules applicable in the EU. This has been done already in the past. When it comes to applicable law, it's not a novelty, it's nothing new. We have done this in the field of maintenance recovery for child support and spousal support. If you look at the maintenance regulation that was adopted in 2009, there is Article 15 is importing the rules of the Hague Protocol directly in the EU. It makes them applicable. So there is no specific rules on applicable law. It's the Hague Protocol that applies. And we have kind of the same for the protection of children, because in the Brussels 2B regulation on parental responsibility, there is also in the recital a reference to the Hague Convention. Again, we always have those interplay between the EU instruments and the Hague Convention. So in Brussels 2B, you will find a reference to the applicable law rules of the 96 Convention on the Protection of Children. So this was just a bit of background. And why did we do so? Well, there were actually two reasons. The first one is of legal nature. The idea was to avoid as much as possible to create two different sets of rules that would create some problems when interpreting the differences. And again, to go back to other existing instruments, we've seen in the area of child protection that because the EU regulation was almost the same but slightly different from the Hague Convention, this has created a lot of questions for the judges and for everyone working in that area. And this has actually led to a number of preliminary rulings to the Court of Justice. And so it took a number of years to know exactly how to combine those two different sets of rules in a cross-border case. And the second reason is more practical, but it's also, those two reasons are interconnected. It's because we've been told that for practitioners, it's actually easy to have because practitioners like judges or legal professionals working in the area of the protection of adults and notaries, they have cases in the EU, but they have cases as well with non-EU member states. And for them, it's already kind of hard to have to apply those private international rules on top of their own national legislations. And if we create two different sets of rules, one applying to the EU, one applying to the rest of the world, this would be even more difficult for them. And so by having the exact same rules applying to any cross-border case, it will make it easier. Let's take the example of an Italian judge who would have a case of an Italian person having assets in Switzerland and in Germany. This court could apply the same rules to determine its jurisdiction and which law will apply to this case, despite the fact that Switzerland is not an EU member state. So those were the two reasons why we chose to make a reference to the Hague Convention. We'll see if the co-legislators will agree and how the text will evolve.
Anyone wants to say anything? No? So let me throw another question. Always, both of you also can answer. Ruth, from what have you seen so far in the Council, does the direct reference to the Hague Convention make it difficult for certain states that have not yet ratified the Convention to accept the draft regulation? Or on the contrary, does this proposal for a complete European framework make it possible to overcome the difficulties of ratification?
Thank you, Almudena. As I mentioned before, we are at a very early stage in the negotiations within the Council. And on the other hand, they are confidential, but I think I can answer this question, at least in general terms. And yeah, so we haven't discussed this topic. I cannot talk on behalf of the 27 member states, but I'm sure probably because everything will be discussed, so probably the reference to the Hague Convention will be discussed, but not because we all disagree or agree with this reference, just because we need to discuss everything. So probably, yes, doubts may arise that need to be clarified to avoid interpretation problems and to guarantee the correct implementation at national level. As Marie said, at the end, you, the practitioners, the notaries, will need to apply this regulation, and it makes sense to have the same or similar rules, or the same rules, applying to relations among member states, but also with third countries. So in this regard, I think this reference to the Hague Convention makes sense. I mean, there is a reason behind. However, I cannot state now that if this reference could create a problem or facilitate the works and the negotiation within the Council. It's soon, but I think not necessarily it's a problem. We need to take into account that we are improving the Convention as well. I mean, it's not just making a direct reference to the Hague Convention. We also are improving in some parts the Convention, or trying to put over the table more measures to protect our adults. So we have time to negotiate about this, and I'm sure we will be able to reach an agreement at the end. As it was stated in the consultations conducted by the Commission for these proposals, the reasons given by the Member States for not ratifying the Convention were very different. Among them, a change in government, internal discussions, the need to make it coherent with the United Nations Convention. So there are many topics over the table for those Member States that didn't ratify or haven't ratified, the Convention, but there was not a criticism of the Convention itself. So I think we will manage to do it.
Okay, thank you. We are in early negotiation, but I think we are in negotiation. The theme is on the floor,
yeah.
So we have to discuss, and we have to try to make a reasonable regulation. So, Marine, the proposed regulation is a step forward in respecting the autonomy of the will of people who have anticipate a possible loss or reduction of their personal autonomy, because their choices will also have to be respected in other EU member states. So, in your experience, it is a common practice to anticipate a possible need of support, need of loss or reduction of their own personal autonomy. Do we have any statistic available in the member states? Can you give us some light on this theme?
Yes, so, well, unfortunately at this stage we don't have data, so that's something that we're trying to collect, because we believe that also at national level that's not something that is well collected. We are actually working on a report that we call Human Rights Report on Legal Capacity, that will be published, I don't think by the end of the year, but we'll have already some information that we can share, but definitely next year in the spring that will be public, to have more evidence on the practice, what is being developed and how it works. But what we do know is that many countries are progressing overall in terms of the autonomy and protecting the autonomy of the person. And what I mean by this is by abolishing full deprivation of legal capacity. So there are more and more EU member states that have done that, by, as I mentioned before, adopting decision-making mechanism in the law that are recognized by law and applicable, and also by adopting support system for further personal autonomy, whether it's formal or informal mechanism, to really support the person in their day-to-day decision. But for this, it's however difficult to have a system recognized in the court if it's something that is informal, but that's also something that exists and that sometimes people prefer to use. So when they can have support within their community, it's much easier than, let's say, going to a court and say, well, I need support in making decision every day. And then they're actually afraid if the deprivation of legal capacity exists, that will be applied to them instead of a measure that is really there to support them. So I also wanted to mention, when we talk about autonomy, I'm taking this opportunity to do that, to mention that actually when there is no anticipation of reduction or loss of the personal autonomy of the person, to be really in line with the UN Convention and what the latest standards of the World Health Organization, we should really look at the will and preference of the person as well, and not at the best interest, which is something that is still being done by in some member states. And that's a practice that is being developed more and more, including by the WHO. So in 2019, there was a course guide developed on supported decision-making and advanced planning that also explain how autonomy should be applied at national level. Again, when it comes to autonomy and when it comes to the Hague Convention, we do see that Europe is behind some other region in the world. So if we want also a wide ratification of the Hague Convention, we actually see that it might be an issue because in Central and South America, for example, several countries have completely abolished the provision of legal capacity, even like curatorship and so on, and they really base all the legislation on supported decision-making. So that's the case in Colombia, in Costa Rica, Peru, and Mexico, where guardianship does not exist at all anymore, and we do see that it is working. I mean, we have reports from other organizations, not EDF, because we only cover Europe, but we'll also put some example in our report. And that's also why, like, part of the question about reference to the Hague Convention, we do understand that the EU will not adopt completely different rules, but we were hoping that they would build actually more on what is lacking in the Hague Convention, which is autonomy, support, because then that would also make it easier afterwards to work with other states that also do not have those guardianship rules still in place. So yes, I don't think I answered completely your question because we don't have data, but I wanted to also talk a bit more about autonomy.
Let me, you have talked about autonomy. I knew you were going to talk about the best interest. It's a word that you don't like, I know, and it's not online with the UN Convention, I know. But I think we can make an exercise, all of us. You have said we have no data, but perhaps all of us, we can think ourselves and think whether we will do an appointment of a person who will make support for us in the future if we know that we are going to have a loss or reduction of our autonomy. And if we will do it by ourselves, perhaps we can see the importance of this matter. Because when one thinks about themselves, perhaps the head changes. Yeah, it's more concrete. That's it. So, Marie, let me ask you: can you explain if all kinds of anticipate decisions are covered by the regulation? For example, let's think, for instance, on an advanced decision on medical treatment, or on the proposal whom to have appointment by a judicial body or other competent, independent and impartial authority as the person assistant in case of a future need of support. These are quite common expressions of the autonomy of the individual concerned, which are not typically powers of representation. They are different. And the UN Convention talks about them. And do you think they are covered by these regulations? Are they covered? Not?
Thanks a lot for this question, which brings us to a more technical and difficult area. So I apologize in advance if I get a little bit more into the nitty-gritty. And also I apologize to those experts because I will have to simplify a bit the landscape to be able to talk about it. So we have two types of what we call anticipated voluntary acts. And it's, again, to simplify a bit, we have the powers of representation, and this is a document where you will, in advance, appoint someone to take care of your personal interests or of your financial interests in the future. And then we have also what you called advanced directives, and those are not powers of representation because you don't appoint anyone, but there you express your wishes and preferences regarding, for instance, which type of treatment you would like to receive if you were sick, or the type of care, or the type of, I don't know, nursing home where you would want to be, or even also wishes regarding your property. And you also have in some states binding directives, which are also advanced directives, which have a stronger value. And there again, you express, you give instructions as to what to do in case you're sick or in case you need some support. But you don't grant powers to someone, specifically to someone. The problem here is that we have a huge diversity in the EU member states. It's impossible to, I have tried to give this overview, but when you look at each individual member state, the legal system is always different. And in some member states, those those anticipated voluntary acts, that just don't exist. In the regulation, we're trying to promote their circulation, but if they don't exist in a specific national legislation, there's nothing we can do, of course. So to go back and to reply to your questions, which types of those acts are covered by the regulation? I will divide those acts into 4 main categories and reply. So the first one would be advanced directives that are not drawn up without any formality. On a piece of paper, in an online form, those advanced directives are not covered by the regulation. Nothing will change for those anticipated voluntary acts because they are completely informal. Then advanced directives are powers of representation that are drawn up in an authentic instrument. Those are covered by the regulation. So typically, an authentic instrument would be a notarial act where the notary would have performed some checks about the statements of the person and recorded their wishes and preferences. In that case, those authentic instruments will have a much stronger evidentiary value, and their evidentiary effects will be recognized in the EU. It means that you will have a valid proof of your statements, of your wishes in all EU member states. So the third category is the powers of representation. And this was already existing in the Hague Convention, and we took it over. When you have granted powers to someone, the Hague Convention provides rules on how to determine the law applicable to those powers, and in particular to know which law will apply to their existence, to their extent, to their modification, and to their extinction. So there we have a set of rules that will be applied to make sure that those powers of representation are in a way recognized, that they circulate because we have rules in the convention as well as in the regulation. And the regulation goes a little bit forward in the way that we've talked about the interconnection of national registers, which is proposed by the European Commission as a groundbreaking measure. And those powers, whenever they are registered in a member state, in a country, then they will be known by all practitioners in the EU because thanks to the interconnection, practitioners will have access to this specific data. And the fourth category of anticipated voluntary acts are confirmed powers of representation. So this is the case in some EU member states, not in all, that an authority, a public authority, confirms the powers to make them enter into force when the person is in, because you grant powers in advance, and at some point you're in need of support, and there a competent authority on the basis of, for instance, a medical certificate will confirm those powers. For those confirmed powers of representation, we will have the European Certificate of Representation. And this is a measure that was very much supported by practitioners, in particular by notaries, because this certificate will be a single form that will be the same in the whole EU. It will be in all EU languages, and it will allow the representative who have been appointed in advance by someone to prove to evidence their authorities, their powers in the whole EU. And this will be in particular very useful for those non-judicial actors that I mentioned in the beginning, the banks, the insurance, the real estate agents, or even the medical staff, who are usually very ignorant of all those very complex legal rules, and they will have this EU form that will establish the powers of someone. Okay, so that was I'm sorry, I apologize for the quite complex and long presentations, but it really reflects the actual diversity of the legal systems, and as we've said already, the EU cannot change the legislation of member states, but we can make it work in an international situation.
The scope is difficult.
Yes.
The scope is difficult. So I will beg you for shortness, because they have told me that we have to we have to finish at 11. There's no way to go on onwards, and I wanted to reserve myself 3 minutes before we end. So, Ruth, questions have arisen about the recognition of decisions that people for more extensive protective measures than those that would have been taken in the state of destinations. Do you think that could the public policy exception be invoked, for instance, in the case of guardianship? I make you that question.
Yes. I think, okay. Maybe Marie can explain this better, but the regulation itself, if you read the regulation, this established among the grounds for refusal of recognition of a measure taken by another member state, the public policy exception, with no limitations to the type of measure. Mm-hmm. So, if I'm wrong, Marie, but I think it's possible to refuse the recognition based on public policy exception, reading the proposal. Mm-hmm. This kind of exception is very common as well within the national legal systems and in other EU instruments. But of course, we have to think maybe, this kind of exception must be exceptional. It's always exceptional. It must be justified on merits and under the control of the competent authorities. So I wouldn't see this public policy exception as an obstacle, but normally it is foreseen as a safeguard to guarantee, for example, fundamental rights. And so I don't know if Marie maybe...
Yeah, do you want to add anything, Marie?
No, just to remind everyone that the principle indeed is mutual trust, and so this is why in most EU instruments there is this automatic recognition of court decisions that have been taken in another member state. And this is what has made it possible for EU citizens to move around, for all those court decisions on divorce, succession, on contract to be recognized very efficiently. And in all types of area in the past, this is what makes the EU so strong, that we mutually trust each other and that we have this very efficient cooperation together. So this is the principle, but of course we need safeguards, and this regulation, this proposal as well as the Hague Convention, we have two safeguards: public policy in general, which includes a breach of fundamental rights. And then we have also the very important refusal ground if the adult was not given the opportunity to be heard and to express his will and his wishes and preferences, then the measure also may not be recognized in the EU. So we are trying to strike that delicate balance between the rights of people and the need to be protected, but also the need to have an efficient cooperation that will be beneficial for the citizens in the end.
Okay, very clear. Ruth, the proposal obliges the member states to set up protection register for measures taken by their authorities and of confirmed powers of representation, and to ensure that those registers are interconnected through systems developed by the Commission. So, how do member states see this obligation, taking into account that such registers, at least not centralized registers, do not exist in many states?
Thank you.
Thank you all.
I have some colleagues here from the Council. Maybe they can answer. But no, I would say, I'm afraid I cannot tell you what all member states think about it. First of all, because we are at a very early stage and the negotiations are confidential. But saying that, we see, other EU instruments, again, foresee this kind of registers and the interconnection of national registers to allow the information flow and be accessible for all competent authorities when dealing with cross-border cases. So my personal opinion is that, of course, this kind of the registers, the interconnection of national registers are an adequate instrument. It's also is important to achieve the purpose of the proposal, because it makes possible the information to flow from one member state to another member state. But saying that, we need to discuss further these kind of dispositions, because it also has a lot of implications. For example, budgetary implications, the time needed for those member states that doesn't have this kind of registers, data protection. Mostly, in this kind of proposal, we are talking about very special categories of personal data, health data. So we need to take into account all these circumstances in the negotiation within the Council, and for sure we will need to discuss this. We have, for example, the opinion of the European Data Protection Supervisor, number 33, 2023, if you want to have a look to this opinion. And in this opinion, I think it's a positive opinion, but they make some suggestions regarding precisely this data protection topic when we are exchanging information among us. So, yeah, I think.
And Marie, how does the Commission envisage this interconnection? And is there already any work done on the system to be chosen, or nothing? What do you think, or what do you know?
So we are lucky enough to draw on precedents in this work on interconnecting registers. This has already been done in other fields of law. If you look at the European Justice Portal, there's a whole section for registers, and there you can go and consult the BRIS, which is Business Registers Interconnection System. You also could have access to the BORIS, which is Beneficial Ownership Interconnection System. So there are multiple registers that exist at national level, or that were developed at national level because of an EU initiative, that are now interconnected. Some are accessible to the public, some only to specific public authorities, and it works. So we will build on those successful experiences, but of course we haven't started the work because we need first the co-legislator to adapt.
I can imagine. We are in negotiations, okay? To all of you, despite the ratification of the UN Convention by all the EU member states, there are still some countries that have not adapted their domestic law to comply with it, particularly with regard to the recognition of legal capacity, Article 12. And the European institutions and the EU the EU has also ratified the convention,
yes,
the UN Convention. So do the European institutions have any way of encouraging the member states to make the required adaptations? Anyone wants to answer? Or I just leave it there, this question, and no one answers?
I mean, for EDF, we have proposal, and we actually do advocate for the Commission to support, or at least to have recommendation or guidelines to support member states developing measure in line with Article 12 and ensure better protection of legal capacity. We were actually hoping that the regulation would push into that direction, and that's not the case. So we're a bit afraid that it will slow down the process. But then we could also take it as an opportunity to build on it and looking at supported decision making in that sense. So it depends what the next step will be.
Marie.
Just a few words to reply to Marine, what she said earlier, that of course supported decision-making measures are covered by the regulation, and that we cover all types of legal systems, including and first and foremost the ones that have just modernized their legislation and that have a very proportionate and human rights compliance legislation. All those measures, if you look at the definition of a measure, any type of measure is covered, and this is also because we don't want to exclude those who unfortunately live in a country where the legislation is not as modern as in others. The protection should be offered to everyone, and then we have safeguards. So this is the idea of the regulation, and I want to stress that the regulation goes really far in protecting in cross-border cases, because this is the limit of the EU competence here. We can't change the law of member states, but we're trying as much as possible to protect the right of autonomy and of self-determination. This is recalled in the recitals and everywhere in the convention. Unfortunately, we don't have the time, but in the proposal, we are trying as much as possible to support this right of those persons.
Thank you, Marie. Ruth, some domestic laws, for example, the Spanish one, they have in the recent years been amended to bring them into line with the UN Convention. This is, has increased the responsibility, for example, for the notaries as an authority of Article 12 of the Convention. So what role do you think notaries can play in the context of the protection of adults, particularly in assessing people's capacity? In short, please. Yes. Sorry.
I will try to be short, yes.
Sorry.
I think it depends on each member state, its national legal system, and the functions and competencies of notaries in each member state. I can talk about Spain. In Spain, for example, I personally think notaries can play a key role in the protection of adults and on this kind of measures. In Spain, for example, notaries play a significant role. It's essential the role you play in assessing the people's capacity when we are talking about the protection of adults. The responsibility, the responsibility of the notary in assessing people's capacity is notably increased, as you mentioned, since the last reform operated in 2021. It will be the notary who, in his judgment, will have to appreciate the degree of natural capacity or discernment of the person in front of him, deciding, in absence of a judicial specification, which should be the best way to proceed so that such person gives his consent with sufficient security and guarantees. Therefore, the responsibility of notaries in this matter is notably increased, and I think you all can play a very important role in the protection of adults, for example, with these preventive powers of attorney or powers of representation. I can talk more, but if you want. But
Thank you. I know you can talk all. We can talk all the morning, but we have no time. Yes. So and the theme is very interesting for all of us. Marine, have you seen any tangible improvement in the last 10 years? Is to have a good message for the floor in terms of respect of rights of persons with disability. If you look forward and you look backward, have you seen any improvement? What are the main points of concern? What step or what direction we should take for the future?
Yeah, so fortunately we did see quite a lot of improvement in the past 10 years, so that's quite positive. We also really appreciate the work of the Commission with the new disability strategy as well. I did mention some change in the law, so now we have at least 8 EU member states who have abolished guardianship. We have almost half of the EU member states, so 13, who have a supported decision-making system established by law. We also saw some member states actually changing. So, for example, if I can name and shame, I don't know, like one member state, Croatia, changed their law, and then the court actually decided to take a step back in terms of supported decision making. So we're quite concerned about actually those step backs. We also, when the proposal was published and in discussion around the Hague Convention, we also had questions when talking with member states about the impact that would have. So I think that would be quite important for also the Commission to clarify how the proposal and the regulation would apply to support decision making. Because, for example, discussing with Ireland, who I believe is the last country who changed their law to abolish guardianship, they were concerned that actually if they have to recognize guardianship from another member state, would that mean that they need to change their law again to have it at national level? So really there were a lot of questions around this, and I think we will need to work hopefully together with the Commission to clarify that, to make sure that that goes in the right direction. And then we also see, like, more broadly when we talk about supporting people who experience mental health issues, that even at the level of the Council of Europe, there have been like more discussion to looking at actually supporting people, looking at voluntary measure instead of depriving people of their rights. But we know that it's a constant fight and effort that we need to continue doing, and I hope that together, like working with organizations with disability, working with government, working with you notaries.
Sorry, I have no time.
We will make like sufficient progress. Thank you.
Sorry, I'm so sorry. I think we have a good message where there are loads of things have been done, and we know that we have loads of things to do in the future. So, Marie, very short, the regulation aims to further facilitate the sharing of good practice among member states at the time of its implementation, for example, through the EG Civil, the EG Justice Portal, the training activities. We have our president of the CNUE here. What could be the role of the notaries in this context, please? What do you think?
It's a very good question, because it's not just another legal text. It's another community. It's a new community of practitioners that will be created through this proposal and then the adoption of the text. And I really believe we've seen that in the past in other areas of law, that this will improve in general the exchanges between practitioners and hopefully go also in the right directions, because when you exchange, you mostly exchange best practices. And when it comes to the role of the CNUE and the notaries in general, this will of course be crucial in this very field of law. The CNUE will probably work together with the working group to develop the fact sheet, the EGN fact sheet that is provided for in Article 67 of the proposal. The CNUE will participate to all the EGN meetings. Of course, the CNUE will have the possibility to apply for grants, to improve the application, but also to train the practitioners, in particular the notaries. And finally, I very much hope that in this complex but extremely important area, there will be a practice guide to help judges, notaries, and everyone apply those regulations. And there again, the notaries will work with us to prepare this practice guide and make it available when the future text becomes applicable.
I'm sure we will. We have lots of work there on, and thank you very much. So I'm sorry I cannot give the floors to the audience. I'm so sorry. I would like to make 3 or 4 conclusions. I'm trying to read them, and so we finish because we have no time. That's it. I'm so sorry. Statistics show that in 2050, 1 in 4 Europeans will be over 65 years old. Moreover, according to the European Court of Auditors Special Report 2023, about a quarter of EU citizens have stated that they live with a disability. Okay? The protection of adults within the EU is of objective interest, and we welcome the proposed regulation. Indeed, Europe needs to address politically the rapid aging of this population, and to do so in a comprehensive way. The European Union's step forward is understandable, given that the issue of the protection of adults in cross-border situations directly points to the very heart of the free movement of persons. Okay? From a practical point of view, we can highlight that the main objectives, goals, purpose by the European Commission proposals of May 2023, which could never be achieved under the autonomous systems of private international law of the various states, despite being well designed. The goals of the proposal will be ensuring continuity in the protection sphere of adults in vulnerable situations when a cross-border or international situation occurs, respecting individual autonomy, including the freedom to make our own decisions and the independence of individuals, ensuring cross-border effectiveness and thus the recognition of support measures or powers granted by an adult in anticipation of their need for support. And finally, contributing to the creation of the area of freedom, legal certainty is all over the floor, legal certainty is so important that, and justice, by providing a coherent framework of private international law applicable to the protection of adults in a situation of disability or vulnerability. From a substantive law point of view, the international protection framework is defined by the Convention on the Rights of Persons with Disability of 2006, ratified by all the EU countries and by the EU itself. And this convention recognizes the respect for the rights, the will and preference of the individual without any conflict of interest or undue influence, and the measures have to be proportionate and adapted to the individual circumstances. Under private international law, there is on one hand a fundamental text, the Hague Convention, and on the other hand, within the EU law framework, the proposal that has been made based on the fact that there are significant substantive and procedural differences between the member states' law. So they have made this proposal for the adoption of a regulation that we all of us know. This proposal challenge is to coordinate or merge the EU text, the Hague Convention, and all under the umbrella of the Convention of the Rights of Persons with Disability. And this challenge is far from simple. It's not simple. So the European notaries, the European Notariat, is at the disposal of the institutions to facilitate the legislative process and to improve those aspects of the proposal that may present greater legal difficulties, providing their specific legal knowledge and practical experience. In relation to the scope of application raises a fundamental question. Are only judicial measures and powers covered, or they are also included support measures put in place by the person before a competent, independent and impartial authority or a judicial body? The direct import of the Hague Convention, which precedes the UN Convention and is logically outdated, limits the reality of the support measures in the proposal. The most important step will be, therefore, to introduce more clearly the autonomy of choice in line with the promotion of self-determination of adults and its compatibility with the New York Convention. What is meant by authority? Who is the authority? The Article 3 of the proposal recognizes the concept of authority, in which the notary is to be understood as an agent of the European area of justice. It recognizes the notion of authentic instrument in the terms of the UNIVAC judgment, and it also codifies the notion of power of representation as a specific protection measure. In short, I think clearer delimitation of the concept of measure will be desirable. Also in relation to the notion of authority of Article 3, in conjunction with Article 12 of the Convention and the special report presented in December 2017 to the General Assembly by the Special Reporter of the Rights of Persons with Disability. The proposal also introduced a new documentary tool, the European Certificate of Representation, following the example of the European Certificate of Association. This will offer the Member States the opportunity to benefit from the notarial know-how and practical experience in this area. I know I have to finish, sorry, but just too short. The introduction of power of representation and confirmed power of representation as different concepts may present greater legal difficulty. Considering confirmation as a public, usually judicial, proceed for determining the existence of vulnerability may pose problems with regard to movement in countries, for example, Spain, where there is no such confirmation proceed. This distinction also gives arise difficulties as regards the disqualification of unconfirmed powers of representation as the basis for issuing the European Certificate of Representation according to Article 36. It is also interesting to reflect on the proper coordination of national register in the interconnection system provided for Article 47 and on the requirement for access to register information. And also respect of the member states' procedures and registration competence should be also needed to be respected. In particular, it should be recalled that the conditions for entering data in registers as well as the effects of publicity should be excluded from the scope of regulation. In conclusion, I think I'm very glad that I have heard all the measures are included, but in conclusion, further considerations should be given to the proposal in view of the difficulty we have on this matter and the significant differences in the rights of the various member states. So thanks to you all. I wanted to read it. We try to do our best. Thanks for the speakers. Thanks, of course, to the organization, and thanks, of course, to you that you have been here. Sorry I didn't give you the word, and that's all. No sé? Qué difícil,
Thank you. Just a short announcement. There's lunch at the 3rd level of the in the Spinelli building, and we will accompany there. And also, thank you very much again for all those who have joined us online. Thank you very much.